The Competition Commission has recommended that the Tribunal approve the $35 billion takeover Xstrata by Glencore, merger approved subject to a condition relating to employment. Now, Eskom applied and was granted the right to intervene in the merger after raising concerns over how the merger could affect the price of coal. So joining us for an analysis of the approval of that merger and other inquiries currently underway is Trudy Makaya, who is Manager of Advocacy and Stakeholder Relations at the Competition Commission. Trudy, there's stuff in the news about your market inquiry powers, which sound threatening, and we want to talk about construction, but let's just start with that Glencore Xstrata thing that I've mentioned there. Okay. What was the issue here? The idea of two big companies coming together, having too much market power, Eskom feeling threatened in terms of the price of its supply?
Yes. So in essence, you have two companies that are very significant, certainly in South Africa, because this was a global transaction. But in South Africa, this raises very pertinent questions around the supply of coal and also obviously the pricing and the conditions at which Eskom could be able to access that coal. Now, in this instance, Eskom did raise certain policy questions that we investigated during our merger assessment. At the tribunal stage of the hearing, they withdrew their formal intervention, though the tribunal still asked them to be heard.
Why did they withdraw?
They withdrew in this instance because it seems they were able to come to some agreement with the merging parties as to how they're going to deal with the issue of coal supply going forward. Yet the tribunal still wanted to hear from them because obviously when there's a bigger policy question, one needs to make sure that the issue is being addressed.
So can we be sure that Eskom's going to get its coal and that they're not going to raise our tariffs by more because the price is higher than they expected?
So in this instance, they were able to come to an agreement with the merging parties. However, it's a general problem that would affect its relationship with all other coal suppliers. So this is an issue where the tribunal had said, in terms of this specific merger, it doesn't really change that much with regards to coal supply and pricing. But going forward, this is something that government policy needs to consider. What would be a strategic coal supply regime for South Africa?
Would you get involved in whether it's a strategic mineral or not, and special conditions and prices have to attach to it?
I think we study markets and dynamics. So in the sense of offering insights about competition in that market, we would do so. In terms of some of our investigations, the general findings that we make about a market, we would share with other policymakers to highlight what the pertinent questions from at least a competition perspective are.
Well, you talk about your findings. Now, there are these market inquiry powers. There was a news story a couple of days ago about you have new powers. The way you guys have been carrying on the last few years, I would have thought you had more than enough power to rule between the competition and the tribunal. So what are these new powers?
So these enable us to look at the general state of competition in the market. You don't want to have an instance where you have these, contrived investigations into specific companies' behavior, when it's clear that the problem actually has to do with the market, be it incentives in the market, be it the way different parties interact, be it the way regulation has set up the rules of the game. So rather you want to look at the market holistically and say, there's, the amendment talks about a distortion of competition or some elimination or restriction of competition in the market. We would have to have reason to believe that that's happening and that there are ways that could be, further inquiry.
What can you do that you couldn't do before? Go into companies, ask for their books?
Exactly. So when we did the banking inquiry, the sector came voluntarily to us. We couldn't really summon individuals to come in front of that tribunal, that inquiry, that panel. We couldn't summon evidence in terms of documents. When we asked questions, it was up to them to answer or not. So in this case, we have all those powers to get information. At the same time, we have powers also to protect information that we solicit, because when it's all voluntary, it becomes a bit fuzzy. Now, the protections around confidentiality, around the right of a witness not to incriminate themselves,
It also suggests that they have less power to make a deal, because if you want them to come forward and they say, okay, we'll come forward, but then you've got to be lenient. If you have increased powers, perhaps they have less bargaining power in that sense.
In that sense. But of course, when something is found to be related to specific company conduct that might be illegal, we could still uncover this through even a generic inquiry. Then it would kick off, normal investigations where if a company cooperates, provides information, undertakes not to undertake in that kind of contravention going forward, we would then go through the normal settlement procedures. So I think it just gives us a better information base. It's more efficient rather than obviously going, if a problem affects the whole industry, targeting a merger to discuss it is not productive. Having a market inquiry to look at the market is the productive thing to do.
Well, one market that you are looking at is the construction sector, and it seems quite shocking in a way is that they all admit that they were doing things, but it struck me, one of our guests the other day, Mike Howarth, was saying, you've got to understand in this sector that cooperation, collaboration, has always historically been quite a big thing. They have big contracts, they divide up things between them. Is that necessarily collusion? Is it necessarily anti-competitive?
It is anti-competitive. I think that the problem is a failure to draw the line between legitimate joint ventures where the client knows I'm dealing with company A and B and C, this is what A is doing, this is what C is doing, versus a situation where a company thinks I'm dealing with B, yet they've had a side deal to say we're going to inflate the price, it's yours this time, it's ours next time. So I think there is a transparent legal way to set up joint ventures. And this is not it. This is collusion. This involves deceiving the client as to what's happening, what they're getting, the price.
The one example was the World Cup stadiums, when all those billions of rand were spent on that. We have a right, I suppose, to ask questions about this. What do you think is going to come out of this? Are people going to go to jail?
So we're going to conclude our process where we enter into settlement in terms of administrative fines. As I said, collusion obviously involves some deception and fraud, etc. Now those would be dealt in the criminal system. We're in the administrative system. So we certainly have been able to uncover information and deliver this information to the nation, so to speak. But other authorities can then
But the fact is they are admitting it, aren't they? So
yes.
Is there going to be a deal there in the sense of, okay, if you're fully transparent and you can demonstrate that you've been fully transparent, we are going to be lighter on you?
Well, I suppose the deal is almost implicit in the whole thing, because by saying we want to hear all about your contraventions all in one pot and you get a fine on that, as opposed to us traditionally going after each and every contract as a contravention, and each and every contract attracting 10% of total turnover. Now we have them all and say, okay, for this basket, you're just going to get this X%, and you're going to undertake not to engage in such conduct going forward. It works out much better than had we gone through that protected process in terms of legal fees, time, uncertainty over the company, and also the actual penalty itself. So it is overall a better deal to be able to do it quickly, efficiently, and all in one basket.
As a rough guideline, listed company, what would the percentage penalty be, and of revenue of?
Well, they vary. As I say, we've all put them in one basket, so we're not necessarily going for the maximum 10% turnover for each project. But that would be the global cap in terms of how much we're able to impose a penalty.
And what sector have you got your eye on next, just briefly?
Well, we're obviously looking at all sectors in terms of economic activity. We've been thinking very carefully about private healthcare as a potential sector for an inquiry. But now that we have these powers, we just have to make sure that we comply with the processes that are now required of us before we undertake it.
Well, there'll be a lot of popular support for that one in particular. That was Trudy. Thanks, Trudy. She's Trudy Makaya, Manager of Advocacy and Stakeholder Relations at the Competition Commission.